Well, it's 82 days.
82 days.
Lordships.
Yes, do you
82
have
days.
objection?
This was, I had shown a Supreme Court judgment on the last occasion, which said that when it comes to 37, the delay has to be strict very fully. In that matter, 75 days delay also Supreme Court did not consider.
Yes. Please come on the merits.
Lordships. My lords, the affidavit is at page 7, my lords. The affidavit is at page 7.
Please come on the merits.
On the merits, Lordships.
Yes, you are under section 37.
Section 37, my lords. Lordships.
So, section 34 application has been dismissed.
Lordships, the arbitral award is against the appellant. Thereafter,
What is
section.
the arbitral award? 23, 2018.
Lordships. 20th March 2018, my lords.
Right.
The arbitral award, my lords, would find it at page 45, my lords.
On what grounds are you challenging the award?
My lords, our preliminary challenge is on the ground that the learned arbitrator did not have jurisdiction, as the purshish under which the disputes were settled to arbitration, that did not encompass the dispute which is raised, was adjudicated by the arbitrator. My lords, so just a few
The jurisdiction was conferred to the arbitrator
Lordships.
with the appointment of the arbitrator
My lords.
on the agreement between the parties
Lord-
or by the court.
My lords, there was a civil suit wherein the parties agreed to go to arbitration by filing a
So civil suit was decided and you were delegated
Lordships.
for arbitration.
My lords.
Now, once arbitrator is appointed, that any issue arising out of the contract
Lordships.
can be adjudicated.
My lords. So, my lords.
Are you saying that a specific issue was referred to arbitrator?
My lords, in the suit preferred, the disputes raised in the suit had to be referred to the
No,
arbitration.
no, sorry.
My lords, that is
What was the dispute in the suit? And where is the order of the civil court?
my lords, the order is at page 1, my lords. The section 34 order, my lords, is at page.
Civil court order.
My lords, the civil court order is part of the paper book. That wouldn't be on record yet, my lords, as it is at the stage of condemnation of delay.
That is not part of record.
My lords, that would be placed on record by way of a paper book, my lords.
No, but that should be part of record at the stage of admission.
Lordships.
Once you are arguing that whatever was this arbitrator had no jurisdiction to go beyond
Lordships.
the terms of the reference,
My lords.
and terms of the reference are within the four corners of the dispute,
Lordships.
which was before the civil court, then we have to see the civil court order.
It's in Gujarati, but on the next page, paragraph 5. સદર ટેન્ડર અંગેની વાદી તથા પ્રતિવાદીઓને જે પણ રજૂઆતો છે તે તમામ રજૂઆતો વાદી તથા પ્રતિવાદી દ્વારા આર્બિટ્રેટર પાસે નિકાલ કરવાની આ સાથે બાંહેધરી આપવામાં આવી છે. So all disputes are referred. Section 16 was preferred. It was rejected on the ground that all disputes are referred. I'm sorry, Section 16 was never filed. Issue was
Can you
raised,
read the order?
but the order is yes.
23/11/2013.
Yes. આજ રોજ પક્ષકારોની વકીલો હાજર છે. વાદી તરફે આંક 33 થી વિડ્રો પુરશીસ રજૂ કરવામાં આવે છે. જે વિડ્રો પુરશીસ વાદીના બાજી સંભળાવવા કબૂલ રાખે છે, જે આંક 33 થી વિડ્રો પુરશીસ રેકોર્ડ કરવામાં આવે છે, સદર વિડ્રો પુરશીસ આધારે હાલનો દાવો આગળ ચલાવવાનો રહેતો ન હોય, આ દાવાનો નિકાલ કરવામાં આવે છે. આ દાવાનો નિકાલ લોક અદાલતના સમાધાનથી થયેલ હોય તે લીગલ સર્વિસ એક્સેપ્ટેડ. So in terms of the purshes at Exhibit 33, which is the document
Yes.
5, 6 and 7 minus 7.
40% of a second settlement also. Second settlement was also there. First on exhibit 40.
Yes,
Where Mr. LC Lakhani was appointed.
that is the other suit. So this is the first suit in respect of which the present proceedings are.
No, the second suit was filed wherein a declaration was sought that the purshish filed in the first suit cannot be implemented, as the authority signing the purshish did not have the
See,
authority.
the role of the purshish was only to initiate arbitration proceeding. That's all.
Lordship.
So scope or jurisdiction of the arbitrator cannot be confined to the purses
Lordship.
or any settlement arrived at that point of time
Lordship.
to withdraw the suit.
My lord.
So this argument is not going to be justified that whatever the terms and settlement and dispute which was referred in the settlement purses,
Lordship.
arbitrator could not have gone beyond that.
My lord.
Because there was a dispute then settlement claim is made by the claimants.
Lordship.
Statement of claim has been made.
Lordship.
So whatever dispute was there arising out of the contract,
My lord.
that was adjudicated.
My lord.
What is the other point?
My lords, just to close on this point, our argument before the learned district court was that as the disputes of the suit have been referred to the arbitration, the arbitration proceedings the arbitrator could not adjudicate on issues which were outside the suit, my lords. The intention of the parties was to refer the dispute encompassed in the suit to arbitration, whereas in the arbitration proceedings, the claimant has expanded the scope and has brought other issues.
That was by the statement of claims
Lordships.
before the arbitrator.
My lords.
So arbitrator's jurisdiction is not confined to any agreement arrived between the parties for the purpose of reference of the dispute to arbitrator.
Lordships. My lords, the second point was that with regard to the right of way, my lords, that has been incorrectly held by the arbitrator. My lords may have the award that is at page 45.
What was the dispute?
My lords, the dispute was with regard to laying down of pipelines and to create the infrastructure for water supply.
Okay.
There was a tender and the tender was awarded to the respondent.
Right.
The respondent could not complete the work within the stipulated time.
Right.
In view thereof, the contract ultimately came to be terminated. The respondent had filed a suit seeking a relief that the termination was illegal. Thereafter, my lords, the push was filed. The issue was referred to arbitration. Another suit came to be filed, regular civil suit number 640 of 2014, wherein a declaration was sought that the push could not be complied with as it was signed without the authority. During the pendency of that proceedings, my lords, another settlement was arrived at, and thereafter the matter was referred to arbitration. Therefore, my lords, the second push is of relevance. In that, my lords,
No
one of the
issues
issues.
of relevance. See, any dispute which was put up
My lords.
in the claim petition, statement of claim by the claimant, after the dispute is referred to, and if that dispute arises out of the contract,
Lordship.
that can be looked into.
My lords.
Because the arbitrator is also required to bring the dispute to its logical conclusion.
Lordships.
So it cannot confine, there is no order of preference directing the arbitrator to decide, or there cannot be, to decide a particular issue.
Lordships. My lords, the second contention was raised, my lords. It is the first issue. My lords have the award at page 45. The issues are framed at page 51. My lords, the first issue: was the respondent responsible to make available right of use for laying the pipeline, and if so, when the same was made available to the claimant? My lords, in that regard, my lords, our submissions are at page 57. 57 are submissions of the claimant, my lords. The observations I may take, my lords, at page 62.
You terminated the contract on the ground that the claimant has not completed it.
Has not completed the work within the time limit, my lords.
Right. Now, where is the finding of the arbitrator in this regard?
My lords, the award is at page 45. My lords, the reasoning start.
There is one issue which is framed as: was the respondent responsible to make available right of use for laying pipeline? If so, when the same was made available to the claimant?
Lordships.
Where is the finding on this issue?
My lords, the finding on the issue can be found at page 62. Tribunal observations and decision on dispute. Dispute number 1. The respondent is under obligation to provide right of use for laying the pipeline as per the provisions of the contract agreement. And My lords, at page 63, a little more details are given. That is all, my lords, just a one-line finding. Some reasoning is given at page 63. Page 63, my lords, under observations and findings of the tribunal at serial number 1 and 2.
Page 62, the tribunal discusses dispute.
Lordships.
Number 1, 2, 3, 4. Will you read that?
Lordships.
And
There are-
after the finding,
Observation
at
page,
page 63.
my lords. On going through the claim statement,
What is this ROU?
the right of use.
See, the finding is that you have failed to provide clear-cut